Hello, Susan.
Hello, Wojtek. How are you?
Fine, thank you. And you?
Oh, I'm really tired.
Yeah, it's the end of
Day
of a year, so I understand you.
Yeah, it's very tiring, very tiring. But this day it was really terrible. So I try to speak. I try to think.
Fortunately, we are finishing our conference, our open seminars, our another duties for today's.
Yes, I hope. I hope the other duties
Yeah.
we will finish.
I can see. Hello, Marta. Hello, Marta.
Hello.
Martas, hello.
Marta, from Poland. Do you know where is the Professor Konrad?
Yes. Professor Falchuk asked for his speech to postpone until then because he's in the delegation on the frontier and he has a work meeting and he will be at 6:30, 6:40, I don't know, but at the end of our seminar.
Okay. And Professor Zuza, do you know where is Erika?
No, no, and I can call her.
Yeah, if possible, please do it.
Okay.
Marto, z Węgier
Yes,
wyjaśniłaś sprawę dokumentów?
Chyba tak. Dzięki, że wysłałeś, bo to chyba brakowało to. Tak mi się wydaje, ale jak nie, to może Konrad mi podpowie później. A, dzięki. Dobrze,
Konrad
widzę.
pisze, że jest ok, także
Okej, super.
wszystko jest ok.
Dzięki.
It's
So-
easy to you to speak in Polish.
Yes, because she had a problem with documents, so everything was clear up, so everything is okay.
Erika will join in some minutes. So she is okay. She is ready to join.
Okay. So I warmly welcome to the fifth open seminar on the protection of rights of the elderly. The agenda, our open seminar includes a short presentation of the results of our research, followed by a discussion or possibly answers to the question asked. For convenience, please write down your questions and ask them at the end after the speeches of our research team members. Each speaker has 10, maximum 15 minutes. The first speaker is Professor Konrad Walczuk, but he's absent. So we will start from Professor Marta Osuchowska. The title of her speech is the lege ferenda proposals for the accessibility of seniors to education and culture and the possibility of gainful employment. Could you start?
Yes,
you
yes,
ready?
of course, I'm ready.
Yeah.
So, good evening, everybody, and once again, and for the last time, we have the opportunity to meet and to present the scientific results in our group. Today, I want to talk about the results of my research by summarizing two topics, and the one of seniors' participation in the culture, and the other one about the ability to engage in gainful employment in retirement. Despite information and promotion campaigns undertaken in Poland and in Europe, as well as co-financing at various levels, the participation of the elderly in cultural and educational activities is one of the lowest in Europe. And seniors in Poland, Polish seniors still use this type of activity less frequently than their peers from Western and North Europe. The main reason are the health problem, and they need to relate it to meeting other more important areas of life, including, for example, social security. Based on the analysis conducted following the lege ferenda, postulates should be put forward. I have a long, a long list for the postulates. First, and the international law, because I think that the international law should seek to harmonize the rules in the member states of international organization with regard to the protection of the right of senior citizens. And the legal norms defining the age of seniors should be clarified not only within one branch of law, but the various branch of laws. European Union legislation should ensure that the rights of seniors are the same in all member states. The Polish legislator, the other group of the postulates that the Polish legislator should take note of the problem of population aging to adapt legal provisions to changing demographic structures. The drafting of new legislation should take into account the experience of social sciences dealing with the situation of older people. And the legislation should take into account the needs of seniors, so drafts should be consulted with representatives of the social groups. As it's okay in Poland with this subject because we have the groups and the proposition of the many cities, but the largest city in Poland. But the other part of Poland, for example, and the east part of Poland is more difficult to do it. So we need to consult with the group of seniors the social needs and the cultural needs. Cultural and educational are higher order needs, so lower order needs, including among others, safety and health, should be taken care of first. It's obviously. Culture and educational, especially for seniors, should also be available in smaller towns and villages. It's also a big problem in Poland. Educational offerings for seniors should include topics oriented towards improving their knowledge, also in the areas of health, physical, culture, etc. It's very important that we can do it in the University of Third Age. It's very popular. Speech about the health, about physical culture, and the physical culture, not only a speech at the university, but activity physical activity of seniors in this university of third age. Legislation should oblige local governments to create special institutional structures aimed at the needs of senior citizens. It's obviously that they can't oblige them, but they can recommend than oblige the local government. But it's very important because the older people they're more often with coordinating with the local government that the other organization or on the part of the citizen. The positional needs of citizens, senior citizens, should be definitely taking into account their possible disabilities. It's also very important that we have know that the disabilities of the senior citizens to take a structure of this area of the culture. Culture and society, I'm sorry. And with regard to the participation of seniors in culture, it's also important to emphasize their role in the creation of culture. There are many institutions that organize theaters, for example, for seniors, vocal assemblies, or dance groups. The recipients of this type of culture are not only senior citizens, It's worthwhile to make seniors active not only just in passive participation in the culture available, but that the culture that is active part, not a passive part of the culture. In this way, they also satisfy other mental and emotional needs, not only just like a passive people, but the active. So they also satisfy their emotional needs. And about my other part of my speech about regard the possibility for seniors to earn a pension. It's very important, and it should be noted that the changes that were introduced this year in Poland are very positive. They allow seniors to raise funds without losing the pension they receive. Thus, a number of demands have been introduced that have been repaired for several years by the legal doctrine and seniors themselves. Therefore, it should be considered that until it's proven how the current changes work, it's worth refraining from new demands. So I really don't have other postulates de lege ferenda in this area, because I think that we have to wait minimum 1 year to account for how these changes work in Poland. But I think it's a very, in my opinion, these changes are very positive. For this time, I will see at the in next year how it was for them. And this is how I wanted to end my speech today. And thank you very much for the opportunity to speak, to cooperate this month, and to get know you. And I hope that we see again, and sometimes, and perhaps we have the opportunity to work together in the future. We read with great interest the scientific papers that we have produced in our research group, because unfortunately, that short speeches did not allow us to present all the phrase on our research, and I think it's very important to read that our work, because it's very great work for us. We could earn this in this month. So thank you very much, and see you next time.
Wojtek, your microphone is off.
We can't hear you.
can't
Yes,
hear you.
I'm sorry. Thank you very much, Professor Marta Skowska. Yes, I can see that she is present. Thank you very much one more. So the next our speaker is Professor Marta Beniusz, who will present the issue actions to increase the protection of the rights of the elderly in Hungarian law. Can you start?
Yes, thank you very much. I'm happy to see you again online.
Hello, Professor Rika.
So, arriving to our finals, I will speak about the second part of my research and the conclusions drawn at this part. So throughout my work, I used a human rights perspective, which indeed led me to look at my final conclusions through this prisma as well. So the question would be whether, in the light of Article 12 of the CRPD, a complete law reform would be needed, which would include targeted actions in order to abolish the currently existing rights-restricting methods. While the existing human rights framework I will not invoke, as I spoke about it several times already. But interestingly, a very similar conclusion shall be drawn when examining the provisions of the Fundamental Law of Hungary. According to the Fundamental Law of Hungary, human dignity is the basis of human existence. It is inviolable. Every person has the right to life and human dignity. The life of the fetus is entitled to protection from the moment of conception. The Constitutional Court recognized the right to human dignity as to be one of the formulations of general personal rights. The general personal right is a mother right, a subsidiary fundamental right that both the Constitutional Court and the courts can invoke in any case to protect the autonomy of the individual if none of the specific named fundamental rights can be applied to given facts. The fundamental law states that everyone is equal before the law and every human being shall have a full legal capacity. Interestingly, under the provisions regulating discrimination, there are not explicit ban on the discrimination on the basis of age, but this is also an aspect that I have already spoken about several times. So in line with the above summarized constitutional framework, every human being under Hungarian legal system bears unquestionably a full legal capacity to which one is entitled due to his or her human nature. It commences from the moment of birth, if being born alive, and ends with one's death. Legal capacity cannot be restricted. Any declaration or legal notice that restricts it shall be considered null and void. Legal capacity to act is fully acquired when someone reaches adulthood, which as a main rule happens when someone turns 18, or in exceptional cases, when someone gets married at 16 with an express consent of the guardianship authority. Legal capacity can be restricted both fully and partially by the guardianship authority based on several grounds. This is a breach both under existing human rights framework as well as under the fundamental law of Hungary. From a human rights perspective, the conclusion would be indeed that a complete law reform and complete law review and the reform is needed. But what are the elements and the criteria that should guide such a law reform? To guide law reform efforts consistent with a reformulation of the criteria of full personhood and legal capacity, we might begin with a general concept of decision-making assistance in the exercise of legal capacity, both informal and formal. However, in order to maximize individual autonomy, it may be necessary to distinguish between people who may require assistance but who want to exercise decision-making on their own without formally designating representatives, and those who may require representatives or other decision-making networks to assist. We also need to distinguish situations where people who may require supported decision-making networks or representatives to exercise legal capacity actually have those networks and relationships already in their lives, and situations where they do not. This is necessary so that state interventions do not unnecessarily restrict autonomy in the provision of support and at the same time maintain the integrity of supported decision-making as a form of decision-making assistance and not simply a more supportive substitute decision-making approach. Therefore, it could be helpful to recognize two distinct decision-making statuses, both of which provide people with full legal capacity, and to distinguish both from the existing substitute decision-making. One would be the autonomous decision-making status. Under this status, a person is recognized as someone who can make and communicate his or her decisions in ways that other parties are able to understand, possibly with some individualized assistance like visual aids, informal advisors, plain language, or augmentative communication technologies. Under this autonomous status, the person would not require others to represent him or her in entering contracts, giving informed consent, instructing counsel. A supported decision-making status respects and protects a person in exercising their full legal capacity as with autonomous decision-making status.
However, it is based on an individual selection, others to represent him or her in making and exercising decision. Supported decision-making networks are based on a relationship of trust with an individual. They are a group of people who commit to assisting that person make and carry out decisions consistent with their intentions and life goals, and in the context of a long-term personal relationships and knowledge of their person. For the majority of people, informal supported network would be sufficient. For the majority of older persons as well. However, in some situations, people may require legally recognized supported decision-making networks because even with accommodations, others are unable to understand their unique forms of communication or may not be able to recognize their personhood without the formal intervention of particular representatives recognized for this purpose. The reason for distinguishing supported decision-making status from autonomous decision-making status, both of which ground a person's full legal capacity, is that an individual's need for some minimal assistance in exercising legal capacity should not be a reason necessarily to impose on him or her the requirement of representative or supported decision-making status. That is, we must be careful about the slippery slope. We must be concerned that in efforts to provide people with decision-making assistance, we do not necessarily require them to have formally recognized supported decision-making networks or representatives, as that would somehow also result in de facto guardianship. What about people who are currently under substitute decision-making and who may not be able to meet the criteria of personhood without significant assistance from others and who are without valuing personal relationship? This is the case for many people with intellectual disabilities, those disabilities that are gained as a result of aging. Because of being isolated, they do not have people or supports in their lives who know them well and value them, and that would help them have their personhood recognized before other parties and the law. The human rights perspective calls for an action against it, and the recognition without unjustifiable restriction should not happen, because under the CRPD, people have a right to the supports they need to maximize their potential to be fully included and participate in society, live independently in the community with others, to have their personhood fully recognized, and to exercise their legal capacity. Under Article 12, there is a presumption, or there should be, that all persons currently under substitute decision-making have full legal capacity until proven otherwise, according to more inclusive criteria of legal personhood along the line outlined above. We know that many people with intellectual disabilities have been placed under substitute decision-making only on the basis of their disability status. With minimal or possibly no decision-making assistance, many could fully exercise their legal capacity. And that would be my conclusion. Thank you very much for the work that we had together. It was a pleasure, and I also really hope that we will meet and have the possibility to work together in the future. And well, we will say Merry Christmas at the end to everyone, but just a little pre-bird. So thank you very much.
Thank you very much, Professor Marta, for some conclusion, final remarks of your research. According to the agenda of our meeting, I'm asking for a lecture, Professor Zuza Wopera. The title of her lecture is Conclusions of the European Union and Hungarian Regulations for the Procedural Protection of the Elderly. Are you ready?
Yes, I am ready, but something happened with my screen. Do you hear me?
Yes, everything is okay.
Because something is changed in my, I don't know what is it. streaming has been initiated.
Yes,
Okay.
we can see you, we can hear you.
Okay, it's okay.
Go on.
It's no problem. No problem. Thank you so much. So, dear colleague, dear participant, good afternoon, all of you. Yes, this is our last meeting, and I would like to share with you in the next few minutes the conclusion of my research in the field of procedural protection of elderly in civil matters, which was my topic in our research team. In the beginning of my research, I put forward the hypothesis that there is regulatory deficit at the field of procedural protection of the elderly. Therefore, there is no effective legal protection. My research conclusions confirm this hypothesis, but let's see the details. First, look at the protection of elderly in EU law. If we look at the fundamental legal framework of EU regulation, we found that there are very few sources of EU law with legal binding force which name the rights of the elderly. The Charter of Fundamental Rights of the European Union, here and after the Charter, is one of the few sources in which the rights of the elderly appear specifically. According to the relevant sources of special literature, one of the most innovative principles of the Charter is the right of the elderly. This principle is not directly enforceable, so it cannot be directly invoked in a legal dispute, either before the European Court or the national courts. The explanation to the Charter makes it clear that Article 25 is a principle to guide the EU institution when they legislate rather than an enforceable right. The significance of the Charter lies in the fact that the secondary sources of EU law must be treated in accordance with Article 25 of the Charter. In my research, I examined the procedural rights of the elderly in cross-border situations. I found that there are no uniform private international law rules applicable in the field of judicial cooperation in civil matters regarding the protection of vulnerable adults in cross-border situations, and there are disparities between member states' laws and jurisdiction, applicable law, recognition, and enforcement of protective measures. EU legal protection is currently represented by the Hague Convention on the International Protection of Adults, here and after the Hague Convention, which was adopted in 2000, but only 13 EU member states have ratified it until nowadays. The Hague Convention establishes uniform private international law rules on the jurisdiction, applicable law, and international recognition and enforcement of protective measures. The Convention applies to the protection in international situation of adults who, by reason of an impairment or insufficiency of their personal faculties, are not in a position to protect their interests. In 2021, the European Commission established that without a stronger EU action, the judicial cooperation would not attain the level of efficiency reached in almost all other civil and family matters in the EU. I found that in order to effectively protect the procedural rights of the elderly, a stronger EU action is clearly needed. It is expected that in the spring of 2023, the European Commission will come up with a proposal for a regulation on all the issues that are not settled by the Hague Convention. At the same time, the adoption of the Council decision on the signing the Hague Convention and the International Protection of Adults on behalf of the European Union is also expected. So in the second part of my research, I undertook to examine the protection of elderly in Hungarian private law. I found that the Hungarian Civil Code introduced the possibility of supported decision-making, but it doesn't abolish, as Marta mentioned, the substitute decision-making. Although there is a separate act on supported decision-making, the regulation remains superficial, perhaps because the supported decision-making decision-making was always intended to be merely secondary or supplementary to the guardianship. It can be established that the Hungarian regulation of supported decision-making is not suitable for the effective procedural protection of persons in need of support. I think a complete reform is needed in this field, which would first require a change of attitude. It could be considered to introduce a new regulatory model instead of supported decision making, where a lawyer with a special qualification as an elderly lawyer would represent an elderly person who is not placed under guardianship but needs support in his or her decisions. We have to mention that there are very well-functioning foreign models in this field, which could be used as a basis for creating and effective regulation. For example, the elder law attorney are known in the United States, and they aid a person in need of support in many areas of life. For example, estate planning, social security, employment discrimination, medical care, grandparents' contact right, not only in procedures. So the fourth part of my research was to analyze the contact right of elderly relatives. The Hungarian Civil Code entitled other relatives to contact with the child for persons other than the parents, including the grandparents. The Civil Code precisely defines those relatives to whom it has the right of contact with the child. Among elderly relatives, the Civil Code designates the grandparents' right of contact with the child, the grandchild. This means that, for example, such a right of the great-grandparent cannot be enforced based on the Civil Code. If the family members do not allow the elderly family member to maintain contact with his grandchild or great-grandchild due to the conflict between them, the possibility of the appropriate legal remedy mechanism must be ensured in the case of the family member who has suffered a violation of his or her right. This means that in the absence of an agreement between the parents and the elderly relative, the elderly relative must be provided of initiating an administrative or a civil proceeding settling contact. According to the Hungarian procedural law, if there is a dispute between the parties regarding the contact with the grandchild, the guardianship authority decides. The Hungarian jurisprudence consistently applies that the grandparents' right to contact is independent of the parents' contact right, and the grandparents' right to contact cannot be restricted because of the bad relationship of the parent and the grandparent. In the area of contact rights, the range of elderly relatives entitled to contact must be clarified, but when extending the range of those entitled to contact, the interest of the child must be taken into account. According to the UN Convention on the Rights of the Child has a right and not an obligation to maintain contact. So I hope that my research in the framework of the Polish-Hungarian research platform contributed to the identification of regulatory problems and the finding an effective legal solution for these problems. Thank you for this opportunity. And I hope that we will have the opportunity to work together in the future. Thank you for your kind attention.
Thank you very much, Professor Zuza. Great speech. Thank you. One more. It's time for my lecture, which is entitled Legal Challenges Related to the Aging of the Society. Aging is a biological effect, a normal stage of human life. It is a natural continuation, although it is associated with numerous limitations. It affects everyone, but it becomes a problem in the public dimension only when the number of elderly people in the general population increases too quickly. Due to the fact that the population aging process affects many areas of social life, primarily economy, healthcare, social security, social assistance, intergenerational relations, it has become the most important issue of the 21st century. In this brief outline of a few selected issues related to the aging population, I will focus on healthcare. Healthcare problems are one of the most serious problems of the elderly. Extending life is inextricably linked to an increased risk of multiple chronic physical and mental diseases that may deprive older people of the ability to function independently. Therefore, expectations related to medical care, support from family members, and the closest environment or public institutions are increasing. The state policy towards the elderly should ensure the possibility of active and healthy aging and support the elderly in leading a relatively independent of the help of others' life in their place of residence. Maintaining social, professional, and family activity as long as possible is also dependent on the right habits and lifestyle from childhood. The goal is to ensure that older people stay healthy for as long as possible. Good health will enable the re-inclusion of the elderly in the economic system of the state. The increasing number of elderly people with a simultaneous decrease in the fertility rate causes labor shortages. On the other hand, the lack of workforce slows down economic growth, which makes it necessary to look for new labor markets, move production abroad, or make changes in immigration policy, which, of course, generates further problems. In the face of declining resources of the working age population, it is necessary to support the existing human capital and take measures aimed at professional activation of the elderly. Skillful use of the economic potential will not only increase production, but will also motivate older people to be active, to take on new challenges, to care for maintaining good health. On the one hand, it will help protect the elderly from unemployment, which leads to poverty and social exclusion. And on the other hand, it will make the elderly perceived as an important resource and not a burden for the rest of society. Therefore, a change is necessary in the area of intergenerational relations in the family and society, which should be based on the solidarity of younger and older generations, which will enable the transfer of knowledge and experience between generations for the benefit of all. Particularly important are the issue of integration and cooperation, ensuring the preservation of social cohesion and coherence. This is related to the need to shape a positive image of the elderly in society that would show old age as a natural stage of human life. One of the ways of building intergenerational ties, overcoming barriers and getting used to old age may be to create support centers for the elderly near schools and kindergartens, and to develop volunteering among both the youngest and the oldest. The progress of civilization has resulted in the extension of life. However, with the increase in the average life expectancy, the fertility rate is unfortunately falling, making simple replacement of generations impossible. The decline in the birth rate means the risk of younger generations not supporting older people. Moreover, the consequence of the aging of the population is not only an increase in the number of elderly people requiring support, but also a decrease in the number of people able to provide it. These unfavorable trends are further aggravated by migrations, causing in particular the outflow of people of working age, as a result of which the number of elderly people requiring support is increasing. Intensive demographic changes are accompanied by changes in family structures and in the social relations between the older and younger generations. This entails the need to organize care for the elderly by informal carers, which will ensure that the elderly can remain in their current living environment. Informal care can be provided both by family members of an elderly person, as well as by his or her friends or neighbors. Unfortunately, however, there is a lack of appropriate legal solutions that would define the rules for supporting informal carers. Meanwhile, caring is often a burden not only physically, but also mentally and financially. In this context, it is necessary to take into account the needs of informal carers providing care for the elderly, including providing them with training adequate to the tasks performed. Therefore, there is an urgent need to develop a new model of supporting informal carers in order to ensure good quality care services. An alternative is institutional help in the form of long-term care and palliative care, which usually involve placing an elderly person in an appropriate care center, which requires a change of residence and separation from the familiar environment of life. Changing the living environment does not positively affect the mental state of an elderly person, which only depends their health problems. Placing an elderly person in an appropriate care center should only take place when it is not possible to provide the elderly person with assistance in their place of residence and should be treated as a last resort. In addition, it is also necessary to properly coordinate all bodies involved in the provision of care for the elderly, in particular, the development of a partnership based on clear rules between the public and private sectors. It is urgent to reorganize the healthcare system and adapt it to the needs of the elderly. This is not only about easier and faster access to geriatricians providing comprehensive healthcare, but also about eliminating communication barriers at every level, from architectural obstacles to the way the doctor communicates with the patient. Elderly patients require more attention, and showing empathy is often the determining factor for them to continue the treatment. In its current shape, the healthcare system does not provide the elderly with health services adequate to their needs, especially in the area of geriatrics and rehabilitation. I cannot fail to mention the need to increase the number of employees in medical professions. In the context of ensuring access to health services, prophylaxis, that is appropriate preparation for old age, serves to postpone and limit the symptoms of old age negatively affecting the physical and mental health of the elderly. This requires an increase in educational activities aimed at raising awareness, which will allow limiting and eliminating behaviors that may generate or intensify health problems in old age. The lack of health education and teaching proper health habits from the earliest years of human life leads to many health negligence, the consequences of which will be felt in old age. The implementation of the necessary changes will contribute to improving the quality of life of the elderly and reducing the cost of their treatment to the benefit of all involved in providing them with proper care and support. Thank you very much for your attention. Last but not least, our master of presentation, if I can say, Professor Erika Varadi-Semane, with lecture of characteristics of age-focused criminality, possible criminal law responses. Professor
Thank you.
Erika, could you
Thank
start?
you. And I try, yes, and I try share my PPT. Just a moment. I hope I can, or maybe from this. And I don't know, do you see my presentation?
Yes, we can see your presentation.
So, start.
Yes, you can start.
Okay, thank you once more for the possibility. In my presentation, in our last time, I would like to speak some words about the possible criminal law responses. But first of all, I would like to say something about this picture. Why choose I this picture? Because my answer belongs to the thoughts of professor, because we know some not nice opinion from the society in connection with the situation of elderly. And one is I submit some opinion, official opinion, and from scientific research. And one is said that the prevailing view of aging as being a burden on welfare states. And the second is that the anti-aging and the discrimination activities is increased in the last years, especially on in social media and on internet platforms. And some not nice but very often opinion is that young people make a lot of sacrifice due to measures aimed at increasing the protection of elderly. This is in connection with pandemic situation and in connection with COVID. And the second is that the elderly are a burden on society. The lives or the life of elderly hasn't too much value, or they are no social utility. And I think so that if we speak about the criminal legal answer, first of all, we have to say some words about the general situation, and we have to change the general opinion of societies, of the citizens about the old people, and this is very important in connection with the criminal legal answers too, because the criminal law, criminal procedural law, or the regulations in connection with the old victims or old perpetrators isn't separate from the other opinion of the society or the other regulations. This is our last time, and in the earlier phases of our common work, I spoke several questions in connection with this subject. First time about the protection of elderly, but it was it was July, and it was an interdisciplinary outlook about the general questions, and this was an overview in connection with the life of elderly. The next times in August, September, and October, I speak about the different position of elderly, and in connection with these questions belongs, of course, to the criminal cases. So first time about the criminal activity in old age, and second and third about the victimization of elderly. In November, in this last dissemination conference, I spoke about the summary of this question, and from an interdisciplinary point of view, and I use a holistic point of view, because I think it was very important in connection with this. And I spoke about the connection between the old people or elderly and the criminal law, criminal procedural law, or prison law. And our last time, I would speak some interesting question in connection with the special problems, because this is not in the main point of our research, but I think so very important too. The one is the institutional violence and system abuse, because I think so that these special forms of victimization is very important among elderly, because the ratio of the old people in different institutions, not only in special old houses or old care system, but in health system, in hospitals, and other too. So the institutional violence and system abuse isn't a similar definition or or phenomenon. Institutional violence includes all methods or procedures, or for example, individual reactions or acts of employees which cause harm to the persons affected by the institutional care, and it has a different different effects, for example, endangering the health, safety, physical or mental well-being of all people, exploiting people in any way, or, for example, abuse of their vulnerable position or status. The system abuse is another definition, but it has a special characteristics. One is that the connection to the victimization is typical indirectly, and the second is that the connection is very complex with the institutional system, because the causes of system abuse is, for example, the application of legislation or so objective circumstances like for example, the lack of financial conditions or human factor programs, etc. It means, or I think so, that this is a very important question in connection with the old victimization, but we have or elderly victimization, but we have very rarely information and not too much research in connection with this. But the data shows that the problem is more important and more higher and more more higher than or maybe than we earlier thought. For example, in Hungary, it was widespread research of ombudsman in connection with special houses of elderly, and it asked workers of these special institutions answered, or more than 64% answered that they had abused the elderly in the past year before this research. The kind of abuse is different. The most or the important kind of abuse is emotional, psychological, but there are financial, physical, or sexual abuse, for example, and more than 10% of abuse concrete form were neglect the old people. This is the one and picture about this situation, but this is not this isn't or hadn't focused on the special elderly group. For example, the elderly who has dementia or other mental illnesses, and the international research showed that average of 3 elderly people who has dementia, 2 of these 3 people became or become victims of abuse. It means that only one demence people didn't has this tragical experience, but 2 of 3 yes, and it's mean the latency and the other effects of this situation and of this abuse is more tragical, and the problem, and to make something against these special forms is very important. For example, to know more about this situation, to strengthening the qualification filter or control to show the real practice in this situation. The second special question is the elders behind the bars. It means there are two different groups. One is in connection with long-term sentences, and the second is the new perpetrators which committed crime at an old age. There are similar problems, but there are different problems too. For example, in connection with sentencing practice or sentencing activity, what could exist, or how could this exist if the old people has horse or other illnesses or psychological or mental problems. And this is more interesting question because the mental problems, for example, the Alzheimer disease or other problems, to have these mental problems, this is the one question. And the second is that these exclude the punishability or not. And so it is a different question. The problem is that and in connection with the long-term sentences or long-term imprisonment or life imprisonment is that this has several negative effects, but these negative effects is more important in connection with elderly or old people, and it means that these people needs a special treatment, but in the praxis, the experts or the workers or other people who belong to the prison system don't typically or generally don't have special education or special competencies to work with these people, with these ill people, with these old people, and the needs of these old people is written sometimes, but in the praxis, this is another question. And the last special question belongs to both situation. If the old people is victim, or if old people is a perpetrator, it's similar in connection with the communications problems because these connected typically to the age processes or to the general health situation of old people. The causes of these problems is sometimes these communication problems belong sometimes to physical reasons, for example, the hearing loss, the slower brain function, or the special character or feature that to decide or to answer the old people needs more time than in other age groups members. And for example, these or sometimes they don't understand the question, etc. This is a general or typical problems in connection with old people, but in the criminal process, the features of the criminal procedure and the features of the activity of judges or prosecutors or others, different from these needs. It means that the people, the experts has or use with a direct, targeted, and effective communication, and very quickly questions, and they are waiting, or they wait for quickly answers, and it's and if the old people doesn't understand the meaning of the questions, or others, it's the answers sometimes very bad, that the judge speak or ask these questions once more, but slowly, but not with other words, and they typically, or usually, they don't help to understand the questions, or don't give more time for old people, and or more patience, for example, to these people, and it means that the secondary victimization happened in connection, for example, these special communications problems. So I would like to thanks for our common work, for your help, of course, and support, and it was for me a very, very a nice common work, and I think so that our work, our research work, was very important, and the question in connection with elderly, we have to continues our work, or personally maybe, because we have to change the opinion of society, and we hope, or I hope, that we will get good consequences in the future. And of course, I wish you say a very, very nice Christmas to every member of our group. Okay, thank you.
Thank you very much, Professor Rika, for a great presentation. As usual, I could see in your presentation flowing money, which was absorbed by the system of protection of the elderly, which shows the range and scale of problems which connected with the elderly, if I understand well.
Microphone. Okay.
Excuse me, I don't hear good your question. Could you repeat? Could you please repeat?
Yes, Professor Rika, I saw flowing money on your presentation,
Yes.
which was absorbed by the system of protection of the elderly. Probably it is a good picture to show the scale and range of problems which are connecting with the elderly. Is it right?
Yes, this picture belongs only to the opinion of other people. This bad opinion. I spoke this in the first phase of my presentation, but I personally think so that we could change the situation without money too, because, for example, in Hungary, there are special strategy focused on elderly, and not only in crime prevention strategy, but in a lot of forms we speak about the needs of old people, and to support the or the importance of the support of old people, and we have institution system, etc. But this is one thing, and second things, the exist the practice of these institutions, but it the to make better to the practice, we have don't have need more money sometimes, but we have more patience, more interesting, more empathy, and others to change the situation in the praxis. And I think so that in connection with the old people, this is very, very, very important. The psychological support, and to hear the old people problems, etc.
Yeah, I agree with you. Thank you very much for your remarks. Has Professor Walczuk joined us? I can't see him. So
I sent him a message, but I don't have any response, so I don't know. I can call him.
mhm. So these were all the lectures prepared for today. I open the discussion. Are there any questions, suggestions, maybe comments? I can't see. I can't hear. So everything seems to be understandable. That means our presentations were quite good. I am happy. I'm very happy. Thank you for attending today's meeting. Today's meeting is our last as a part of this edition of a project commissioned by the Institute of Justice. So let me thank the management of the Institute of Justice for trusting us and trusting us with research on the protection of the rights of the elderly. It was a really interesting scientific challenge. I would like to thank, of course, you, my team members, for your cooperation, for a friendly atmosphere, and timely completion of the tasks. Without you, this project wouldn't be as unusual. I am glad of our meeting in Warsaw that I could meet some of you in person. I am counting on cooperation in the implementation of other scientific projects in Poland or Hungary. Who knows? Special thank I am directing to Konrad Burdziak for coordination and supporting our efforts related to the implementation of this project. Konrad, thank you very much. Closing today's seminar, I would like to remind about the deadline for submitting the second report with research results by 15th of December. Are there any matters we should discuss? Yes, Marta?
Yes, I just wanted to ask and make a quick clarification about the documents that needs to be sent for the until the 23rd. So is it that we have to make an extra report from the 1st to the 15th of December? Is that correct? That needs to be sent to you, and afterwards an invoice and everything for this half month.
Maybe.
Yes, you're correct.
Okay, thank you.
We direct to Konrad.
Yes. Okay, thank you, Konrad.
Yes, Marta is correct.
Okay.
You have to send Appendix 1, Appendix 2, Appendix 3 till the 23 December.
Okay, and it should cover the period between 1st of December until 15th of December. Is that correct?
Exactly.
Okay, perfect. Thank you.
Thank you very much, Konrad, for your help. So, time to finish. I'm closing our seminar. I wish you a peaceful night and all the best. Thank you very much.